Hello, class. We're now going to turn our attention to the review for the second exam. Be very similar to the review for the first exam, obviously just different content. So let's go ahead and jump right into it. These slides, the first few slides, are the same as they were for the first exam review, where we talk about exam preparation, doing the reading beforehand, etc. And hopefully after the first exam, you had a better sense of how to prepare for the second one. Again, just a reminder, very rarely, if ever, do I give makeup exams, only if it's very well documented, compelling reasons. I take your communication into consideration. If you're late to an exam, you lose 1 point for each minute that you're late to the exam. You're not able to take the exam after the first person has completed the exam and turned it in. If you show up after that time, you receive a 0 on the exam. I take academic dishonesty very seriously, or refer to judicial affairs with the recommendation that you receive a 0 or an F in the course. Time can be an issue on the exams. They're time compressed, as you all know now after having taken the first exam. If you continue writing, bubbling, filling out scantrons, etc., after time has been called, then in those circumstances I refer you to judicial affairs as having violated the rules regarding academic dishonesty. I only grade what's on the Scantron or in the Blue Book, and in the Blue Book if you're in the honors class. So make sure you've got those Scantrons and Blue Books fully completed at the moment that I call time. The day of the exam, you've been through this once, so you know how it goes. In the non-honors classes, you need a number 2 pencil and a Form 882E Scantron. Pass out the exams right at the beginning of class time. Takes me a few minutes to do that. As soon as everybody has their exam, I get the class started all together, and I call time at 50 minutes past the hour to end the exam. I give 5-minute and 1-minute warnings during the exam with reminders to make sure you get your Scantrons bubbled, and the time is displayed in class on the projector. In the honors class, number 2 pencil, Form 882E Scantron, a Blue Book. Again, remember to get the bigger ones, not the small one. You can use a pen if you'd like to write your essays. You may be allowed a note sheet. Again, we discussed that in class if that is relevant. Begin passing out the exams at the beginning of class, and you have 75 minutes to complete the exam. Can't write after time has been called. Give a 5-minute and a 1-minute warning, and then display the time in class as you go through the exam. Just a reminder, you all now know this since you've taken one exam. The exams are challenging. Review is just high level. I go through things that I think are really important, that I try to stress things that students have missed on exams in years past. Studying the review alone is not going to be adequate preparation for the exam. Make sure you're working the practice questions, reviewing your class notes, reading the chapters, asking me if you have any questions. And remember, anything that we have discussed in class that was assigned as reading or is in the textbook is fair game for the exam. And as you've seen, now that you've taken an exam, the questions are very heavily application-based. So make sure you get a good night's rest, eat a healthy breakfast, make sure you make effort to manage your time appropriately on the exam. Now let's jump into the material for Exam 2, which is entirely focused on contracts. Chapter 11 is a high-level introduction to contracts, and it lays out sort of a roadmap, if you will, for the other material that is covered in the additional contracts chapters. So we talk about the elements of a contract, and a contract is essentially just a legally enforceable agreement. And generally speaking, there are 7 key characteristics: offer and acceptance, consideration, legality, capacity, consent, and then certain contracts require a writing. Some other important issues that we address in the contracts unit include third-party interests, performance and discharge, and remedies. So when we talk about contracts, we realize that they come in all shapes and sizes. They can be big, small, public, private, etc. They can have large impacts on society, and people can enter into contracts without even knowing it sometimes. Again, the definition of a contract is that it's a legally enforceable agreement, and we're going to walk through the elements to make a determination as to what constitutes that legally enforceable agreement. Contract law developed over time, started with the English courts, which were a little slow at first to recognize the significance of promises. but courts now view them as almost sacred, but they do review them for basic fairness. The different types of contracts. So this is an important slide. This is a concept that students sometimes get confused by. When we talk about bilateral and unilateral contracts, a bilateral contract is a promise made in exchange for another promise, and this is the vast majority of contracts. I promise to paint your fence if you promise to pay me $500. I make the promise to paint your fence. You make the promise to pay $500. We are now bound in contract at that point, assuming all the other elements of contract have been met. And that's a bilateral contract, a promise in exchange for a promise. A unilateral contract is a situation where one party makes a promise that the other party can accept only by actually doing something. So an example of this is if my dog goes missing and I put a sign up in the neighborhood that says $500 reward for return of lost dog. The only way that you can bind me in contract and therefore force me to pay you the $500 is to show up with the dog, to bring me the dog back. You have to do something. I promise to pay $500 only if you do something, and that something is returning the lost dog. Executory and executed contracts. This just has to do with whether the contract is completed or not. An executory contract is an agreement in which one or more of the parties has not yet fulfilled its obligations. An executed contract is an agreement in which all parties have fulfilled their obligations. So executory, there's something still open, hasn't been completed. Executed, the agreement has been fully completed. This is a really important slide as well. So this lays out some definitional terms that come up again and again throughout the contracts chapters. A valid contract satisfies all of the law's requirements. That's what we're going to be talking about over the next several chapters, are what are those particular requirements. An unenforceable agreement occurs when the parties intend to form a valid bargain, but a court declares that some rule of law prevents enforcing it. So an example of this is an oral agreement for the purchase of land. As we talked about with the statute of frauds, the purchase or sale of land or any interest involving land, a contract dealing with land has to be in writing to be legally enforceable. If it's not, it's unenforceable. So what that is saying is it's a valid agreement. Like, you can buy and sell land. There's nothing illegal about that. But there's a rule of law, the statute of frauds in this case, that prevents a court from enforcing it if it's not put in writing. Avoidable contract is an agreement that may be terminated by one of the parties, so they can stay in the contract if they would like to. And an example that we talked about is a minor, somebody under the age of 18, has the ability to void a contract. They can stay in the contract and enforce the contract if they choose to, but they have the option to void it. A void agreement is an agreement that neither party can enforce because the bargain is illegal or one of the parties had no legal authority to make it. So a contract for the purchase and sale of illegal drugs would be a void agreement. Neither party is going to be able to enforce that because the purpose of the agreement is illegal. Express and implied contracts. Express contracts are pretty straightforward. It's an agreement with all the important terms explicitly stated. This is the vast majority of contracts, and it can be oral or written. An implied contract is where students get tripped up a little bit. It's an agreement in which the words and conduct of the parties indicate that they intend an agreement. So they didn't sit down and formally, expressly agree to contract with one another, but there's an implied contract based on their words and conduct. So an example of this would be, the example I use in class oftentimes is, neighbor across the street mowing their yard. I ask them to mow my yard. They come over and mow it. I pay them $25. The next week, I ask them to come over again. They come over and mow it. I pay them $25. Third week, they come over, mow the yard. I give them $25. Fourth week, they come over, mow the yard. I give them $25. Fifth week, they come over, mow the yard. I don't give them a check. They knock on the door and ask for $25, and I say, we didn't have a contract. We didn't have an express contract. We never sat down and said, here are the terms. On every Friday, you come over and mow my yard. I'll give you $25. But we had an implied contract. It looks like we had an agreement where they would come over and mow my lawn and I would pay them $25. Some sources of contract law. Common law. Again, remember back to Unit 1. Common law is judge-made law. These are court decisions that create the common law. There are differences between jurisdictions, which can be confusing as people start to contract, or as people started to contract across different jurisdictions. So the Uniform Commercial Code, the UCC, makes an attempt to make contract law more uniform. What the Uniform Commercial Code does not do is federalize contract law. Contract law, for the most part, continues to be state law. And there's this large influence of common law still. There is more statutory law, and a lot of that is Uniform Commercial Code. So the Uniform Commercial Code by itself is not law. The states have to adopt the Uniform Commercial Code in their legislatures and then have that law signed by the governor in order for the terms or some of the terms of the Uniform Commercial Code to actually become law. So it does not federalize law, it makes law more uniform if states choose to adopt it, which happens to a very large extent. So some situations where we have non-contracts, so things that are not contracts that courts still may enforce as contractual. The two big areas that we talked about are promissory estoppel and quasi-contract. These are pretty uncommon exceptions to the general rules, but they do come up in certain situations. One thing I want you to be sure that you remember on the exam is there is not a contract in place if we are talking about using promissory estoppel or quasi-contract. These are tools that can be used by a plaintiff if there is no contract. The best way to distinguish between the two remedies is that in promissory estoppel cases, the defendant made a promise that the plaintiff relied on. In quasi-contract cases, the defendant received a benefit from the plaintiff, and retaining that benefit would be unfair. So let's talk about these in a little more detail. Promissory estoppel is a possible remedy for an injured plaintiff in a case with no valid contract. There it is again, we don't have a valid contract if we're using promissory estoppel. When the plaintiff can show a promise, reasonable reliance, and injustice. Even when there is no contract, a plaintiff may use promissory estoppel to enforce the defendant's promise if he can show the following. The defendant made a promise knowing the plaintiff would likely rely on it. The plaintiff did rely on the promise, and the only way to avoid injustice is to enforce the promise. So if you make a promise to a charitable organization that you're going to donate $1 million to the United Way, when you make that promise or that pledge, there's not a contract most likely in place because they're not giving you anything in return. There's no consideration. So when you make that pledge to give $1 million, no contract, if you do not give the $1 million, you have not breached the contract because there was no contract in place. But the United Way or whatever charitable organization it was may be able to make a claim that there was promissory estoppel. You're now being sued by the United Way to recover this $1 million that you pledged. If we look at the elements of promissory estoppel, the defendant made a promise. You promised to give them $1 million. It was part of a pledge campaign, so you knew that they were likely to rely on it. The plaintiff did rely on the promise, so the United Way would have to show that somehow they relied on that $1 million pledge that you made. They went out and bought new equipment, they hired another person, they expanded their operations, whatever it might be, they'd have to show that they relied on the promise. And really, we have to make a determination as to what's fair here. The only way to avoid injustice is to enforce the promise. You made a promise, wasn't contractual, but a court may go ahead and enforce that because you made the promise, you knew they would likely rely on it, and they did, in fact, rely on it. Quasi-contract is a little bit different. It's a possible remedy for an injured plaintiff in a case with no valid contract. So again, the key is we're using quasi-contract because there was no valid contract. When the plaintiff can show benefit to the defendant, reasonable expectation of payment, and unjust enrichment. Even when there is no contract, a court may use quasi-contract to compensate a plaintiff who can show the following things. Plaintiff gave some benefit to the defendant. Plaintiff reasonably expected to be paid for the benefit, and the defendant knew this, and the defendant would be unjustly enriched if he did not pay. The damages that can ultimately be awarded to a plaintiff are called quantum merit, which means as much as he deserves. So, company shows up at my house, landscaping company, they're mowing my yard. Actually, let's change the scenario a little bit. And let's say a sprinkler company shows up at my house and they're putting in a new sprinkler system in my yard. they're not supposed to be there. I have no contract with them. They're at the wrong house. They got confused. They're putting in the sprinkler system, and I see them doing it over a couple of days, and I don't say anything. And then they give me a bill, and I refuse to pay because they were at the wrong address. We didn't have a contract. We didn't have promissory estoppel, or we don't have promissory estoppel because I never made a promise to them that they relied on. But we probably have quasi-contract. The plaintiff, this irrigation company that's putting in the sprinkler system at my house, clearly gave me a benefit. I've got a new sprinkler system. The plaintiff reasonably expected to be paid. Well, I knew that, well, they were doing this professionally. They're a professional irrigation company putting this in. I knew that. I knew they expected to be paid. So element 2 is satisfied. And then element 3 is the defendant would be unjustly enriched if he did not pay. It's unfair for me to get this benefit without paying for it when I had an opportunity to stop them. If I'm out of town for a month and I come back and then all of a sudden I've got a new sprinkler system and a bill for it and they were at the wrong address, I don't know anything for that. I'm not being unjustly enriched. I didn't know they expected to be paid. I didn't even know they were doing the work. So in the situation that I first gave you where I see them over a couple days and I don't say anything, I am being unjustly enriched. If it happens while I'm gone, not being unjustly enriched. That brings us to chapter 12, and we start to dive into our first elements of contract, offer and acceptance, which make up the agreement. So in order to have a legally enforceable contract or agreement, we have to have a meeting of the minds. One side has to make an offer, and the other side has to make an acceptance. An offer is an act or statement that proposes definite terms and permits the other party to create a contract by accepting those terms. The acceptance is an unconditional agreement to the terms of the offer. So we have to have that to have the meeting of the minds. That's what creates this contract. Courts make objective assessments when evaluating offers and acceptances. Don't forget that. Objective means what would a reasonable person assume is being said, agreed to, etc. in these circumstances. Subjective is more your personal feelings, taste, judgment. Courts are not interested in your subjective feelings or views in this particular context. Courts make objective assessments. When we talk about offers, the offeror is the person who makes the offer. The offeree is the person to whom the offer is made. So first, let's take a look at some statements that usually do not amount to being offers. Invitations to bargain, price quotes, letters of intent. As we talked about in class, those things are generally not seen as offers. Advertisements and auctions generally are also not seen as offers. So an advertisement is a request for others to make offers. With an auction, when you place the item up for bid, that's not the offer. It's a request for others to make offers on that item. The bids are what become the offers. There can be problems with definiteness in an offer. The terms of the offer have to be definite. This throws students all the time on the exam. Give you a simple example. I own 100 acres of property, and I divide it in half, 2 50-acre lots, and I want to sell both of them. You and I enter into a contract, or I make an offer. I make an offer to you to sell you one of the 50-acre lots for $1 million. You accept. Is that enforceable in court? And the answer is no, because my offer was not definite enough. Which of the 2 50-acre lots did I offer to sell you? Didn't say. Okay, so the offer has to be definite enough in order for it to be enforceable. Now, the Uniform Commercial Code addresses this to some extent. Article 2 of the Uniform Commercial Code governs contracts when the primary purpose is the sale of goods. 2-204, paragraph 3. Now, just to be clear, on the exam, I'm not going to ask you specific questions about specific paragraphs or subsections of the Uniform Commercial Code. So you don't have to memorize the number. You need to know what the outcome is. And what this particular section says is, even though one or more of the terms of an agreement or offer are left open, a contract for sale does not fail for indefiniteness if the parties have intended to make a contract and there is a reasonably certain basis for giving an appropriate remedy. So essentially what the Uniform Commercial Code says is when we're dealing with contracts that involve sale of goods, they'll fill in the gaps. Oh, you left out the price. The offer and acceptance occurred, but there was no price. The Uniform Commercial Code will establish a reasonable price. Have the two of you dealt with each other in the past? What's the market rate? What's a fair price? That's what the Uniform Commercial Code is going to be looking at. Output and requirements contracts, we'll come back to these. The consideration that occurs here is that the code requires both parties act in good faith. So how do we terminate an offer? Well, there are several ways that an offer can be terminated. I offer to sell you my car for $500. The offer can be revoked. I take it back. I can do that anytime before the offeree accepts. Now, you want to make sure that you remember revocation is effective when received by the offeree. Make sure you understand that point. If I'm the offeror and I want to revoke the offer, my revocation becomes effective when the offeree receives it. There are ways that contracts can be made temporarily irrevocable. The one that we focused on in class is the option contract. This applies to all types of contracts. An interested purchaser, somebody who wants to buy something, pays additional money for the right to have the offer held open. Somebody's offering to sell you something, you pay them a little bit of extra money, give me 10 days to think about it. That is an option contract. The offeror cannot revoke the offer during that option period. There's something called a firm offer, which applies only to Uniform Commercial Code contracts. And it's a writing that's signed by a merchant, and a merchant is someone who is in the business of selling that particular good or product. They offer to hold open the offer for a stated period of time, and that cannot be revoked, even if there's no money that's paid. So the open period cannot exceed 3 months. So they can sign it and say, we'll leave this offer to sell this car at this particular price open up to 3 months. Beyond 3 months, you're going to need some sort of payment in order for that to be effective. You can have an offer that's terminated by rejection. The offeree can hear the offer, see the offer, receive the offer, and say, no thanks, not interested. Okay, that automatically terminates that original offer because the offeree has rejected it. If, however, the offeree makes a counteroffer, so I offer to sell my car for $500, and the offeree says they'll buy the car for $400, that's a counteroffer, and a counteroffer acts as a rejection of the original offer. It terminates it automatically. There can be termination by expiration. The offer might set a timeline, a time limit. In 6 months, this offer expires. In 6 minutes, this offer expires. At the expiration of that time limit, the offer has expired. If the offer specifies no time limit, then the offeree has a reasonable period of time within which to accept, and a court would make that determination as to what's a reasonable period of time. Then there can also be termination by operation of law. If an offeror dies or becomes mentally incapacitated, the offer terminates automatically and immediately, regardless of when the offeree finds out about it. Offeror dies or becomes mentally incapacitated, automatically terminates the offer, regardless of when the offeree hears about it. So make sure you understand that, because it's a little bit different than that rule where the revocation becomes effective when received by the offeree. Here, it doesn't matter when the offeree finds out about the death or mental incapacity. If the subject matter of the offer is destroyed, that will automatically terminate the offer. And if there's supervening illegality, if something is offered at a time when it is legal and then whatever was offered becomes illegal, that will automatically terminate the offer as well. Now we shift our gears from offer to acceptance. The offeree generally must say or do something to accept. So inaction on the part of the offeree generally does not constitute acceptance. The mirror image rule ties into this idea that we just talked about with a counteroffer being a rejection. And the mirror image rule requires that the acceptance be on precisely the same terms as the offer. That's the common law rule. Common law mirror image rule says offer and acceptance have to be exactly the same. The Uniform Commercial Code changes this rule just a little bit. And the way it changes it is when we're dealing with merchants and we're talking about sale of goods, there can be additional or different terms that are added in, and we call this the battle of the forms. An offeree who accepts, so an offer has been made and the offeree wishes to accept, the offeree can include in that acceptance terms that are additional to or different than those in the offer. The offeree might state in her acceptance that it's conditioned on the offeror's assent to the new terms. So the offeree adds in some new terms, sends it back to the offeror and says, I accept as long as you agree to these new terms. If the offeror doesn't accept those new terms, we have no contract. Additional terms bring up new issues, and assuming that both parties are merchants, the additional terms generally do become part of the contract as a default. In 3 circumstances, additional terms will not become part of the contract. The original offer insisted on its own terms, the additional terms materially alter the original offer, or the offeror receives the additional terms and promptly objects to them. Different terms contradict each other. So the offer says one thing, the acceptance says another thing. Those are different terms. They contradict one another. Generally, what most states are going to do is they're just going to knock both terms out, and they'll use the Uniform Commercial Code to add in sort of the standard Uniform Commercial Code terms into the contract. Click wrap and browse wrap agreements. We talked about this. When you click I accept or I agree, essentially you have accepted those terms. Communication of acceptance. I'm not terribly concerned that you can tell the distinction between method and manner, but I am really concerned that if an offer demands acceptance in a particular method or manner, you understand that the offeree must follow those requirements. If it says acceptance must be delivered UPS overnight, next day delivery, and you choose a different way, the offeree chooses a different way to accept, there's no contract. So if an offer demands acceptance in a particular method or manner, the offeree has to follow those requirements. If the offer does not specify a type of acceptance, then the offeree may accept in any reasonable manner and method. So the offeror has the control to set what they want the acceptance to look like in the offer. If they fail to do that or choose not to do that, then it's up to a court to determine whether the manner and method were reasonable. It's a key slide. There will be questions on the exam about this. I'm going to give you the trick for the mailbox rule. When you see a question on the exam about the mailbox rule, there's a pretty decent chance that it'll be a long passage with lots of dates. Okay, there are going to be lots of different dates in there, some historical dates, some dates about different things that happened. You have to look through those dates and find 2 dates. There are only 2 dates that you care about. For a mailbox rule question, you care about the date of dispatch of the acceptance and the date of receipt of the revocation. Okay? You care about when the offeree dispatched their acceptance. When did they put it in the U.S. postal mailbox? When did they hit send on the email? When did they leave the voicemail? That's the dispatch. Okay? It's now out of their control. You also care about when the offeree received a revocation from the offeror. The mailbox rule says that acceptance is generally effective upon dispatch, meaning the moment it is out of the offeree's control. So on these exam questions, as long as the acceptance has been dispatched prior to receipt of the revocation or termination of the offer, we have a contract. If the termination or revocation of the offer was received before the acceptance was dispatched, then we have no contract. Make sure you understand that. That will be on the exam, guaranteed. Now we get to Chapter 13 and consideration. So let's dive in and start talking about what consideration is. Consideration is the inducement, price, or promise that causes a person to enter into a contract and forms the basis of the parties' exchange. 2 basic elements to consideration. We have to have value and we have to have a bargain for exchange. Value means consideration requires the legal benefit to the promisor or a legal detriment to the promisee. The bargain for exchange says that the parties must have bargained for whatever was exchanged and struck a deal. So what kind of things constitute value? Act, forbearance, promise to act, or forbear. Act is pretty straightforward. Any action that a party was not legally required to take in the first place is adequate consideration. Forbearance is refraining from doing something that one has a legal right to do. So if, for example, you get into a car accident, it's the other party's fault. The other driver gets out of the car and they say, I'll give you a check right now for $5,000 for the damage I caused to your car, as long as you agree not to sue me. The consideration there is the act of giving the $5,000. Okay, that's the act on the part of the party that caused the car accident. Your consideration is forbearance. You're giving up the legal right to sue this person that just caused the car accident. Therefore, we have consideration on both parts. One is an act, one is forbearance. A promise to act or forbear can also act as consideration. A promise to do or not do something in the future counts as consideration. So a case that we talk about in class is Hammer v. Sidway. This is a really important case. The idea here will show up on the exam. And the idea essentially is that if you promise to give up doing something you have a legal right to do, that constitutes adequate consideration. So if you promise to give up driving your car for a year, and you have a driver's license and you own a car, you have a legal right to drive the car, you have the ability to drive the car, you gave up that right, that is adequate consideration. If you promise to give up smoking marijuana in a state where that is illegal, and it's illegal under federal law, so this applies probably across the board. If you give up the legal right to smoke, or promise to give up the legal right to smoke marijuana, there is not adequate consideration because it's illegal for you to do that. So you don't have the ability to make that sort of promise and have it act as consideration. So what's a bargain for exchange? Well, the parties have to bargain for the consideration, and what that really means is that something is sought by the promisor and given by the promisee in exchange for their promises. So this doesn't mean necessarily that there has to be a long back and forth battle between the two parties. It just means that I'm doing something to induce you to do something. I promise to paint your fence. You promise to pay me $500. We have a bargain for exchange. Courts don't analyze the economic terms of an exchange to determine whether consideration was adequate. So something that consideration is not, illusory promises do not constitute adequate consideration. An illusory promise is a promise that doesn't really commit the promisor to do anything. I promise to give you all A's at the end of the semester if I feel like it. I promise to sell you everything I want to sell you. That's not really a binding promise and therefore doesn't act as adequate consideration. Now there's a little bit of an exception to this, which we've already seen, which is requirements and output contracts. These contracts were generally not enforced under the common law because parties could produce as much as they want or take as much as they want. But the Uniform Commercial Code expressly allows output and requirement contracts, and it says that in the sale of goods, as long as the parties are acting in good faith, that's what constitutes their consideration. A pre-existing legal duty does not constitute adequate consideration. If someone provides a service that she is already obligated to provide, that act does not constitute consideration. There are some exceptions to this rule. If you ask somebody to do additional work and they agree to do additional work, there's adequate consideration. If there's a modification of the contract, so you rescind and draft a new contract, now there's adequate consideration by both parties. And if there are unforeseen circumstances, something that couldn't be anticipated at the time the contract was entered into, that probably led to additional work, then in those circumstances, the pre-existing duty rule would not apply and there would be adequate consideration. Past consideration is not adequate consideration. This comes up on the exam. Students get confused by this sometimes. But the baseline is a completed act cannot be the basis for consideration. So if someone rescues you, you were involved in a car accident, somebody comes along, the car's on fire, they get you out of the burning car, they didn't cause the accident, they're not a police officer, they had no legal duty to rescue, but they save your life. They come visit you in the hospital while you're recovering, and you say, "Thanks so much for saving my life. I'd like to give you $10,000. There's no contract there because you are thanking them for something they did in the past. That's past consideration. If you run up to the burning car, they're barely conscious, they're hanging on, and you're like, there's nothing I can do for you, the car might explode, it's too dangerous, and they say, if you rescue me, I'll give you $10,000, you open the door and rescue them, now potentially we have a contract. There might be some issues about whether they made that promise under duress or not, but in those circumstances, at least it's not a situation of past consideration. There was a bargain in exchange. Save my life and I'll pay you $10,000. Not, thank you for saving my life, I'd like to pay you $10,000. The settlement of debts comes up on the exam, and there's really only one thing that you have to focus on understanding, and then just remember what the rules are for each situation. You need to be able to know the difference between a liquidated debt and an unliquidated debt. If you have an auto loan, you have a loan that you're paying on a car, and you pay $250 every month. You signed a contract that said you would pay $250 every month for 5 years. That's a liquidated debt. There's no dispute as to the amount that's owed. So with a liquidated debt, if the creditor agrees to take less, so if your auto loan company says, oh, we'll accept $150 this month, you write them a check for $150 and they cash it. Even if they say that's full payment or that's okay, that agreement is not binding. So there's an exception for different performance. So if instead of giving them money, you worked for them for a while to pay off that debt, then in those circumstances, that's different performance, and they wouldn't be able to come back and sue you for the difference in value. But with a liquidated debt, if you pay less and they accept it, they can still sue you for the difference. Things are different with an unliquidated debt. An unliquidated debt is a debt that is in dispute, either because the parties disagree over its existence, do we owe each other anything at all, or do you owe me anything at all, or as to the amount. The parties can enter into an agreement to settle for less than what the creditor demands, and such a compromise is called an accord and satisfaction, and it's enforced if the following is true. The debt is unliquidated. That's the key, right? The debt has to be unliquidated. The parties agree that the creditor will accept as full payment a sum less than what has been claimed, and the debtor pays the amount agreed upon. We can have accord and satisfaction by check. Again, this only works if it's an unliquidated debt. You write full settlement on the check, causes it to act as an accord and satisfaction when cashed or deposited by the creditor. There are a couple of UCC exceptions here. Organizations can require that checks that claim to be accord and satisfaction are sent to a particular address. And creditor can repay the amount offered as an accord and satisfaction within 90 days of cashing that full payment check, and then sue for the entire amount. Some special consideration cases, agreements not to compete. In a non-compete agreement, an employee promises not to work for a competitor for some time after leaving the company. There are some questions in the law about what constitutes consideration in this situation if the employee has already started working at the time they sign this contract and they don't get any other kind of raise or contractual benefit. The moral consideration, this is just another way to look at promissory estoppel. A judge has the discretion to ignore the fact that consideration does not exist if a promise causes foreseeable reliance by a plaintiff and a great injustice to be done if the promise were broken. Again, promissory estoppel, an example is making that promise to donate to charity. We now move into Chapter 14 and our discussion of legality. We talked about several different types of situations where legality might come into play. And we start with the broad category of contracts that violate a statute. We talked about wagers. So a gambling contract is illegal unless it's a type of wagering specifically authorized by state statute. Morality plays into this, and the key with this is that contracts for an illegal purpose are void. And void really means exactly that. A court will not intercede to assist either party to an illegal agreement, even if its refusal leaves one party obviously shortchanged. Another category that we talked about is insurance, and life insurance in particular. If you take out a life insurance policy on another person, you have to have an insurable interest in that person. If the insurable interest is lacking, there's generally not going to be any contract. The licensing statutes that we talked about, this is important. Students get tricked up on this on the exam. The key is to know the distinction between the two different types of licensing statutes. When a licensing requirement is designed to protect the public, any contract with an unlicensed worker is unenforceable. So if you enter into a contract with a plumber, the reason a plumber is licensed is to protect the public. A lawyer, lawyers are licensed to protect the public. Accountants, licensed to protect the public. If you enter into a contract with them and they are unlicensed, that contract is void, meaning you don't have to pay for the services you received. If a licensing requirement is designed merely to raise revenue, so there's no test to make sure that the people that are doing whatever it is are properly qualified to do it. There's no background check. There's nothing designed to protect the public. It's just to raise revenue for the state or local or federal government. The contract can be by an unlicensed person and still remain enforceable. So even if the contract is entered into by somebody who is unlicensed, if the purpose of the licensing requirement is just to raise revenue, the contract with that person is still going to be enforceable. Usury laws, they prohibit charging excess interest on loans. A lender who charges a usurious rate of interest might forfeit the illegal interest, perhaps all of the interest, or in some states, they actually forfeit the entire loan. The key to this is that if they are charging interest above and beyond what the legal limit is, that it's state law that will make the determination as to what the penalty or consequences are. When we talk about credit card debt, the Supreme Court has ruled that when national banks issue credit cards, they can use the rate of the state from which they are issuing or that of the consumer. They can pick whichever one is higher, and of course that's what they're going to do. Some contracts that violate public policy, a judge may declare a contract void even if it does not violate a statute. Contracts that promote immorality or illegality may be viewed as unenforceable if a judge so rules. The restraint of trade and non-compete agreements. To be valid, an agreement not to compete must be part of a larger agreement or ancillary. So this confuses students sometimes. What this is saying is that the two examples that we talk about are a sale of a business and employment. The primary purpose of those two agreements is not to limit competition. The primary purpose of the purchase and sale of a business is to buy and sell the business. The primary purpose of an employment agreement is to have someone employed and know what the terms are of their employment. When a non-compete agreement is ancillary, meaning part of a larger agreement, to the sale of a business, it is enforceable if it's reasonable in time, geographic area, and scope of activity. With employment, in the absence of a specific state statute that somehow limits the ability of non-compete agreements in employment, a non-compete clause in an employment contract is generally enforceable only if the following is true. It's reasonably necessary for the protection of the employer, provides a reasonable time limit, has a reasonable geographic limit, it's not harsh or oppressive to the employee, and not contrary to public policy. So you can see there is a bias against non-compete clauses. You have to jump through these hoops and make sure that you meet all of these requirements in order for the non-compete to be enforceable either in the sale of business or the employment context. We then talk about exculpatory clauses. An exculpatory clause, if you remember, is just a contract provision that attempts to release one party from liability in the event that the other party is injured. Exculpatory clauses, you see them often. When you click I accept or I agree on almost anything online, there's probably exculpatory clauses in there. If you go skydiving, there are exculpatory clauses telling you that if you get hurt, it's not their fault. If you park your car in a parking garage, there's probably an exculpatory clause that says that the owner of the parking garage is not responsible for any damage or theft involving your vehicle. So we see these a lot, and there are situations where they are not enforceable. So that's sort of this laundry list of things we have here. An exculpatory clause is generally unenforceable if it attempts to exclude an intentional tort or gross negligence. If the affected activity is in the public interest, such as medical care, public transportation, or some essential service. generally going to be unenforceable if the parties have greatly unequal bargaining power, and it's only going to be enforceable if the clause is clearly written and readily visible. Unconscionable contracts are contracts that courts refuse to enforce because there's some level of fundamental unfairness. There's procedural unconscionability and substantive unconscionability. Procedural unconscionability involves a situation where one party uses its superior power to force a contract on the weaker party. The focus is on oppression or unfair surprise. Substantive unconscionability is a situation where a contract has extremely one-sided and unfair terms. A plaintiff has to show both of these, that there was procedural and substantive unconscionability. With adhesion contracts, these are standard form contracts. So again, when you click on something, I accept, I agree online, that's an adhesion contract because it's offered as a take it or leave it. If you don't like the terms that Facebook offers or that Apple offers when you download iTunes, you don't really have much option. There's not a back and forth negotiation. It's take it or leave it. So courts are more on the lookout for unconscionability when there's an adhesion contract because one of the parties didn't have any opportunity to bargain. The Uniform Commercial Code, the drafters reinforce the principle of unconscionability. So that is something that exists in the Uniform Commercial Code. The code does, however, also allow limitations on remedies, and those two provisions can conflict with one another from time to time. We're now into Chapter 15, voidable contracts, where we talk about capacity and consent. Capacity is the legal ability of a party to enter a contract. Someone may lack capacity because of his young age or mental infirmity, both of which we'll talk about. When we talk about consent, we're talking about whether a contracting party truly understood the terms of the contract and whether she made the agreement voluntarily. Consent issues arise in cases of fraud, mistake, duress, and undue influence. With voidable contracts, this is a situation where the injured party may choose to terminate it. Again, remember, it's only the injured party that has the ability to terminate. Capacity is the legal ability to enter into a contract. Minors can enter into contracts that they're able to enforce, but they generally are only creating voidable contracts. A minor for contract purposes is anyone under the age of 18. A voidable contract may be canceled by the party who lacks capacity. A key point, only the party who lacks capacity can cancel the agreement. If two 16-year-olds enter into a contract, either one of them can void it because they both lack capacity because neither one of them is 18. If a 16-year-old buys a car from a Ford dealership, only the 16-year-old can void the contract because they're the only ones that lack capacity. A minor who wishes to escape a contract can generally disaffirm it, and that's they give notice of refusal to be bound by the terms of the agreement. A minor can also actually undo a contract that's already been completed by filing a suit to rescind the contract. Rescission is canceling a contract. A minor who disaffirms a contract has to return the consideration he has received to the extent he is able. And restitution is what we call restoring the other party to its original position. Most states do not require a minor to provide restitution if they're unable to do so. So you give back the consideration in whatever shape it is in, and you don't have to pay for any damage that you've caused to it if you're a minor in most states. A minor can disaffirm any time before turning 18, and they can actually disaffirm for a reasonable period of time after turning 18. A month after you turn 18, depending on the circumstances, might be reasonable. 2 years after you turn 18, not reasonable. A year after you turn 18, also probably not reasonable. It would be up to a court to make the determination as to what amount of time is reasonable. Depends on the circumstances, depend on what was purchased, depend on the terms of the contract. But, within a short period of time after turning 18, probably reasonable. Once you get beyond, a very short window after turning 18, probably no longer reasonable. A minor can ratify a contract after turning 18, and that reduces the ability or eliminates the ability to disaffirm. Ratification involves words or actions that indicate an intention to be bound by a contract. There is an exception to this rule involving minors for what we call necessaries, things like food, clothing, shelter. A necessary is something essential to the miner's life and welfare. On a contract for necessaries, a miner must pay for the value of the benefit received. They can still void the contract, but they have to pay for anything that they've already received. Misrepresentation of age is another exception. There's not a clear rule among the states. Some states actually will still allow a miner who lied about their age to disaffirm the contract. Others will not. Mentally impaired persons. A person suffers from a mental impairment if by reason of mental illness or defect, he is unable to understand the nature and consequences of the transaction. A party suffering a mental impairment usually creates only a voidable contract. The presumption in the law is that an adult is mentally competent. So, if you want to try to void a contract claiming mental impairment, the burden is upon you to prove to the court that you were mentally impaired to the point where you didn't understand the nature and consequences of the transaction at the time you entered into the contract. The law does create one exception to this rule. If a person has been adjudicated incompetent, a court has declared them incompetent, then all of the future agreements are void. Not voidable, they're void. They no longer have any contractual capacity. When we talk about intoxication, one party could be so intoxicated that they don't understand the nature and consequences of the transaction. They would then have the ability to void the contract. But again, remember, the burden is upon them, if they're an adult, to prove that they were not mentally competent or that they were mentally impaired at the time that they entered into the contract. A mentally infirm party who seeks to void a contract must make restitution. So that's different than the miner, right? The miner generally does not have to make restitution. The mentally impaired person does. What that means is if the mentally impaired person is unable to make restitution, they're probably not going to be able to void the contract. They're going to have to rely on something else. Some bad faith, fraud, duress, undoing, something like that. They're going to have to rely on something else because they're not going to be able to make restitution and therefore not be able to void the contract based on their mental impairment. When we talk about fraud, it begins when a party to a contract represents something that is factually wrong. An injured person has to show the following things. The defendant knew that his statement was false or that he made the statement recklessly and without knowledge of whether it was false. He didn't even bother to check facts. The false statement was material, and the injured party justifiably relied on the statement. So element 1, intentional or reckless misrepresentation of fact. It does not have to be a lie. That's important to remember. Opinions and puffery do not amount to fraud. So you can share your opinion about a product you're trying to sell, and we often call this puffery, right? It's a bloated sales language. It's part of the sales pitch. Consumers should realize this. You can't then rely on that sales pitch when it's an opinion and then sue for fraud. If a car dealer, car salesperson, tells you that this will be your favorite car you've ever owned, that's puffery. If they tell you the car gets 35 miles to the gallon, that's a factual statement that could be the basis of a fraud claim. Element 2 is materiality. The injured party, the one that's suing for fraud, has to demonstrate that the statement was material or important. The statement is material if it was likely to influence the decision of the misled party significantly. Element 3 is justifiable reliance. Injured party has to show that she actually relied on the false statement and that her reliance was reasonable. There's no duty to investigate. A party to a contract has no duty to investigate the other party's factual statements. The plaintiff's remedies for fraud. In the case of fraud, the injured party generally has a choice of rescinding the contract or suing for damages, or in some cases, they could do both. Contract is voidable. Uniform Commercial Code 2721, dealing with the sale of good, permits a party to rescind a contract and then sue for damages when fraud is committed. We can also have an innocent misrepresentation. So the party that made the false statement made it in good faith. They actually really thought that what they were saying was true. If all the other elements of fraud are present, except the misrepresentation of fact was not made intentionally or recklessly, we have innocent misrepresentation, and most states will just allow rescission in those circumstances and not damages. There's a special challenge when we talk about silence. The original rule was buyer beware. Basically, no duty at all to speak up. Okay? The buyer didn't have to say anything. If they knew there was something defective about what they were selling, the seller didn't have to speak up. They didn't have to say anything to the buyer about the defective condition of that product. Now there are 4 situations, we'll see on the next slide, where a seller may actually have an obligation to speak up. If they made an assertion previously that turns out to be incorrect, the seller has to speak up. If there's a basic mistaken assumption on the part of the buyer that the seller is aware of, the seller has to speak up. If there's a mistaken understanding on the part of the buyer regarding some writing that is essential or important to what is being sold, the seller has to speak up and correct that mistaken understanding. Or if there's a relationship of trust, a party has to speak up if they know that there is something that should be addressed. Now let's talk about mistakes. A unilateral mistake occurs when only one party enters the contract under a mistaken assumption. If that mistaken party wishes to rescind based on that unilateral mistake, they have to demonstrate that they entered the contract because of a basic factual error and the non-mistaken party knew or had reason to know of the error. The mistake is mathematical or mechanical alone, or enforcing the contract would be unconscionable. So you have to have all 3 of those elements, and the error has to have been based on factual situation. Mutual mistake, both contracting parties share the same mistake. If the contract is based on fundamental factual error by both parties, contract is voidable by either one. Generally, when the parties are mistaken as to the existence or identity of the contract's subject matter, contract is voidable. An example we talked about in class was whether the cow could have calves or not. If it can't have calves, it's worth a lot less than if it can. If both parties believe that the cow is sterile, can't have calves, and it turns out that it can, they negotiated based on the factual error that cow was sterile when in fact it could have calves. That would be an example of a mutual mistake and would allow either party to void the contract. A court will not permit rescission of the contract if there was merely a prediction error or a mistake of value, or if there was conscious uncertainty, somebody who's willing to take a risk. I'm not sure if it can have calves or it can. I'm not going to take it to a vet. I don't want to pay for it. If it can have calves, it's worth $2,000. If it can't, it's worth $1,000. I'll give you $1,500 and take my chances. That's conscious uncertainty. Duress involves a situation where there's an improper threat made to force another party to enter into a contract. This can be a physical threat. Essentially, the party signing the contract or entering into the contract had no reasonable alternative. It can also be economic. In most but not all states, the idea of economic duress can also be used to void a contract. Undue influence. Injured party has to demonstrate that there was a relationship between the 2 parties of either trust or of domination, and there was improper persuasion by the stronger party, and this allows the injured party to ultimately rescind the contract. Chapter 16 takes us into written contracts. So as we've talked about, the vast majority of contracts do not require a writing to be legally enforceable. You probably want to have a writing. That way you have better evidence if you have to go to court. But oftentimes a writing is not required. There are certain situations, which we're about to talk about in Chapter 16, where a writing is required for the contract to be legally enforceable. The statute of frauds says that a plaintiff may not enforce any of the following agreements unless the agreement or some memorandum of it is in writing and signed by the defendant. The agreements that must be in writing are the following: transfer of an interest in land, agreements that cannot be performed within 1 year, in which a party promises to pay the debt of another, made by an executor of an estate to pay a debt of the estate, made in consideration of marriage, and for the sale of goods of $500 or more. So if it's any of one of those, has to be in writing to be legally enforceable. Key point before we move from there, has to be it's unenforceable but not void. So 2 parties make an agreement covered by one of the 6 topics we just talked about, has to be in writing to be enforceable. But once the contract is fully executed, it makes no difference whether it was written or not. So for example, we enter into a contract, I'm going to sell you my house, you're going to buy my house, we don't put it in writing. That violates the statute of frauds. The statute of frauds requires that any contract involving an interest in land be in writing to be legally enforceable. We've made an unenforceable agreement. So if I refuse to sell you my house, you sue me for breach of contract, you're going to lose. We didn't have a contract, it's unenforceable because we didn't put it in writing. But if I move out, you move in, I take the money that you paid to buy the house, and then I try to go back to court and sue you saying, oh, we never put it in writing, A court's going to say it's unenforceable but not void. It's been fully executed, makes no difference whether it was unwritten. So let's start with agreements for an interest in land. A contract for the transfer of any interest in land must be in writing to be enforceable. This means any legal right regarding land. Now, there are a few exceptions to this. If there's full performance by the seller, seller has completely performed their side of the contract, a court will likely enforce this agreement even if it's oral. If there's part performance by the buyer, so the key here is the buyer of land might be able to enforce an oral agreement if she paid part of the purchase price. So that's step one. You have to have paid part of the purchase price and either entered upon the land or made improvements to it. So you have to pay part of the purchase price and then do one of those two things. And then, of course, there's promissory estoppel, which we have seen in multiple occasions, which might come up even if there's an oral agreement for an interest in land. This, I think, is the most challenging of the protected interest to understand. Agreements that cannot be performed within 1 year. Contracts that cannot be performed within 1 year are unenforceable unless they are in writing. If a contract could possibly be completed, if it is possible that it could be completed within 1 year, it need not be in writing. Let me stop right here and give you the example that throws students on the exam. If I promise you and I enter into an agreement that you're going to be my teaching assistant for the rest of your life, we shake hands on it, but we don't put it in writing. Does that agreement have to be in writing to be legally enforceable? Based on this rule, if a contract could possibly be completed within 1 year, it need not be in writing. The answer is that agreement is enforceable even though it is not in writing. Because it is possible that that agreement for you to be my teaching assistant for the rest of your life could be fully performed within 1 year. You could die within 1 year's time. Even if it's highly unlikely, it is possible. Therefore, that agreement does not have to be in writing. And another important thing to remember is it doesn't matter if you end up being my TA for 50 years. All that matters is at the time we entered into the agreement, is it possible? And if the answer is yes, it's possible, no writing is necessary. If the agreement will necessarily take longer than 1 year to finish, it has to be in writing to be enforceable. Simple example. You and I agree that you'll be my teaching assistant for 2 years and we shake on it, but we don't put it in writing. That is necessarily going to take longer than a year to finish. You can't be my TA for 2 years in less than 1 year's time. Therefore, that agreement has to be in writing to be enforced. Promises to pay the debt of another. I think this is the easiest one. When one person agrees to pay the debt of another person as just a favor to that person, it's called a collateral promise, and it has to be in writing to be enforceable. It's just not something that people do very frequently. People don't go around promising to pay the debts of others. So if they're going to do that, and if we're going to hold somebody to that in court, we want to see a writing. Now, there's an exception to this rule, which we call the leading object rule. When the promisor guarantees to pay the debt of another, and the leading or primary object of the promise is some benefit to the promisor himself, then the contract will be enforceable even if unwritten. So if the reason I promise to pay somebody else's debt is to benefit my business, for example, the main reason I'm making that promise is not because I want to help that other person out, it's because I want to help myself out. I need that for my business. Okay, so therefore my oral promise, even though not in writing, would be enforceable under the leading object rule. Promises made by an executor of an estate. This is similar to the promise to pay the debt of another. It's just the executor making a promise to pay the debts of someone who is deceased. If that's going to be legally enforceable, it has to be in writing to be enforced. Promises made in consideration of marriage. If a promise is made in consideration of marriage, has to be in writing to be legally enforceable. What does the writing need? Well, it has to be signed by the defendant, and it has to state with reasonable certainty the name of each party, the subject matter of the agreement, and all the essential terms and promises. Signature is very broadly defined. Essentially, any mark or logo placed on a document to indicate acceptance generally satisfies the statute of frauds. The writing has to be reasonably certain, can't be incomplete or too broad, too many terms left open, has to be certain enough that a court can interpret what is meant. So it has to be reasonably certain. Written document has to be clear and complete, or it does fail. Electronic signatures are valid in all 50 states, although in most states there are still certain documents that require a traditional non-electronic signature, for example, a will in many states, is required to be signed by hand. The Uniform Commercial Code's statute of frauds says that a writing for the sale of goods priced $500 or more is necessary to make that agreement legally enforceable. The basic rule says that a contract for the sale of goods of $500 or more is not enforceable unless there is some writing signed by the defendant indicating the parties reached an agreement. The key difference between common law and UCC is that the code does not require all the terms of the agreement to be in writing. Code is essentially looking for an indication that the parties reached an agreement, and then it's going to do everything it can to enforce that agreement. Really only two requirements: the signature of the defendant and the quantity of the goods being sold. Have to have that in order for the UCC to be able to help you out. There's a merchant's exception in the Uniform Commercial Code. If both parties are merchants, that is, business people who routinely deal in the goods being sold, the UCC accepts an even more informal writing. If within a reasonable time of making an oral contract, a merchant sends a written confirmation to the other merchant, and the confirmation is definite enough to bind the sender, then the merchant who receives the confirmation is also bound by it unless he objects in writing within 10 days. So, I'm a car salesperson. I own a dealership. And I need to purchase 10 Toyota Camrys because I've sold them off my lot and I need to replace the ones that I've sold. So I call another car dealership owner. So we're both merchants. We're in the business of buying and selling cars. And I say to that merchant, I want to buy 10 cars. And I say, great, we'll sell you 10 cars at $20,000 a piece. Fantastic. We hang up the phone. I follow up with an email. Great to talk to you today. Nice to catch up. Thanks so much for helping us out. I agree to pay you when you deliver the 10 cars next Monday at a price of $20,000 per car. If the other car dealer owner doesn't respond to me within 10 days, then that email acts as a writing. Because I bound myself to spend $20,000 per car for 10 cars. If they don't respond within 10 days, we've got an agreement. We both have to be merchants for that to work. There can be special circumstances. So an oral contract for the sale of goods, $500 or more, can be enforceable even without a written memorandum if they're specially manufactured goods. So you order specially manufactured goods, the company you ordered from them, they're going to be $1,000. The company you ordered from them starts making them and they wouldn't be able to resell them elsewhere. Even though you didn't put it in writing, that would be legally enforceable. If you admit in court that you had an agreement, oh yeah, we had that agreement to, I was going to buy that product for $1,500. Doesn't matter if it was in writing or not once you admit it in court. And then if the seller has delivered the goods or the buyer has paid for them, the contract may be enforced even if there was nothing in writing. Okay, this is an important slide. Students miss questions on this all the time on the exam. So I'm going to try and make this as simple as possible. When you have a contract, you probably want it to be an integrated contract. An integrated contract is a writing that the parties intend as the final complete expression of their agreement. So we have done our homework, we have negotiated, and everything we want is in this final written agreement, an integrated contract. In order to make it clear to the court and to both of the parties signing the contract that it is an integrated contract, you probably want to include an integration clause. That is a statement in the contract clearly proclaiming that the writing is the full and final expression of the parties, and anything said before signing or while signing is irrelevant. So you both sign that, all the parties sign it, there could be more than two, all the parties sign it, everybody's on the same page. This is an integrated contract, everything we agreed to is in the body of this agreement. Anything outside of that integrated contract is what we call parole evidence. So earlier negotiations, drafts of the contracts, things that were said just before we signed, while we were signing the contract, anything apart from that written integrated contract itself is called parole evidence. The parole evidence rule says if the parties made an integrated contract, neither one gets to bring in that parole evidence to contradict, vary, or add to its terms. So you're locked into what is in that particular contractual agreement if it's an integrated contract. The parole evidence rule keeps all the parole evidence out. Now, of course, there are exceptions. One exception is an incomplete or ambiguous contract. A court might determine that the written contract is incomplete or ambiguous, and it has to let in that outside evidence to figure out what the parties meant or to close out the contract if it was left incomplete. There's also an exception when there are situations of fraud, misrepresentation, or duress. Court permits parole evidence of those things to be admitted in court. We've now seen all the elements necessary to have a legally enforceable agreement or a contract, and we now get to look outside of the contract. How does the agreement or the contract impact third parties? So a third-party beneficiary is someone who is not actually a party to the contract. So they didn't sign the contract, they didn't agree to terms of the contract, but they do stand to benefit from it. An intended beneficiary is someone who can enforce the contract because the parties actually intended to benefit them. So the parties agreed as they were entering into their contract, we are entering into this contract with the intent of benefiting a third party. That third party who is intended to be benefited by the contract has the right to sue if the contract is breached. An incidental beneficiary is someone who might have actually benefited from the contract, but the parties to the contract had no intention of benefiting them. The incidental beneficiary is therefore not able to sue if there's a breach of the contract. When we talk about assignment and delegation, assignment is a transferring of contract rights. A delegation is a transferring of contract duties. So with an assignment, we have an assignor and assignee. The assignor is the one making an assignment. The assignee is the one receiving an assignment. The obligor is the party obligated to do something, and the obligee is the one who has the obligation coming to her. So let's talk about what rights are assignable. Here's something that students often miss on the exam. Any contractual right may be assigned unless one of these exceptions applies. So if on the exam it says true or false, all contractual rights may be assigned, the answer is false because there are exceptions. If the question on the exam says generally contractual rights may be assigned, the answer to that would be true. Generally they can be assigned, not always because there are exceptions, but generally. They can be assigned unless it would substantially change the obligor's rights or duties under the contract, the assignment is forbidden by law or public policy, or it's validly precluded by the contract itself. How rights are assigned? In general, an assignment may be written or oral. Either one works. If someone, however, wants to assign rights that are governed by the statute of frauds, has to do that in writing. An assignment is valid with or without consideration. An assignment for consideration is irrevocable. A gratuitous assignment that's just made as a gift, there's no consideration involved, is generally revocable if it's oral and irrevocable if it's written. The assignment is valid from the moment it's made, regardless of whether the assignor notifies the obligor. So it is valid the moment that it is made. After assignment has been made, the obligor has been notified. The assignee may enforce her contractual rights against the obligor. So assignment has been made. Obligor has been notified of the assignment, so they now know that they owe their duty or obligation to someone else. That assignee can then sue the obligor if those rights are not satisfied. The obligor may generally raise any defenses that they might have against the assignee if they're the same that they would have against the assignor. The assignor's warranty, when an assignor makes an assignment, the law implies certain warranties or assurances on the part of the assignor. Unless the parties expressly agree to exclude them, the assignor warrants the following. The rights he is assigning actually do exist, and there are no defenses to the rights other than those that would be obvious, such as non-performance. The assignor does not warrant that the obligor is solvent. So the assignor is not making any assurances that the person who now has to, or the entity that now has to pay money to the assignee is going to continue to have money to do so. There's a special issue under the Uniform Commercial Code, and as I mentioned in class, I'm just most concerned here with the fact that you know what a security interest is, rights in personal property that assure payment on the performance of some obligation. Simple example, you have an auto loan. So you take out a $10,000 loan so you can buy a car and you pay $250 a month. The lender, the bank that gave you the $10,000, has a security interest in your car. If you stop making payments to the bank on the loan, they can come and repossess the car, sell the car to pay off the loan. So now we shift from assignment, which involves rights, to delegation, which involves duties or responsibilities. The delegator is the one who delegates the duties. The delegatee is the one who assumes the duties. Most duties are delegable. So if on the exam it said true or false, most duties are delegable, that would be true. If it said generally duties are delegable, that would be true. But delegation does not by itself relieve the delegator of his own liability to perform the contract. So the delegator still has responsibility to follow through. Not all duties are delegable. So if on the exam it said true or false, all duties are delegable, you would know that that is false. An obligor can delegate his duties unless one of the following exceptions applies. That delegation would violate public policy, original contract prohibits delegation, or the obligee has substantial interest in personal performance by the obligor. A novation is an interesting avenue or opportunity for parties, for a delegator in particular, to be able to remove itself completely from the agreement. A novation is a three-way agreement in which the obligor transfers all the rights and duties to a third party. The obligee agrees to look only to the third party for performance, so it lets that delegator completely off the hook. It essentially removes that person from the contract and inserts another party. Now, Chapter 18, we begin our discussion of contract termination. So when we talk about discharge, we're talking about a party being discharged when she has no more duties under the contract. Most contracts are discharged by full performance. Both parties have done what they said they would do. They're both discharged from the contract. Sometimes the parties can discharge a contract by mutual agreement. So they decide to rescind the contract. They want to go their separate ways. That does happen on certain occasions. A condition is an event that must occur before a party becomes obligated under a contract. There are different ways that conditions can be created. They can be created expressly or implied by the conduct of the parties. The types of conditions: a condition precedent occurs before the duty arises. So this is the example of, I want to buy your car, but I'm going to take it to my mechanic. And if my mechanic says that it's in good working condition, I'll be obligated to buy the car. That's a condition precedent. A condition subsequent is the duty already exists. So you work for a law firm, you're an attorney, you have your law license. The obligation of you to work and them to pay you exists. But there could be a condition in the contract that says if you lose your law license, you lose your job. That's a condition subsequent. Precedent is before the obligation exists. I'm not buying your car unless the mechanic says it's good. No obligation to buy it. Condition subsequent is after the fact. I already work here. You already pay me. We have this agreement. If I lose my law license, that condition is not satisfied. I would then lose my job. Concurrent conditions. Both parties have a duty to perform simultaneously. And at times, a court will refuse to enforce an express condition on the grounds that it's unfair and harmful to the general public. So that can happen in certain situations. When we talk about completion of a contract, strict performance requires one party to perform its obligations precisely with no deviation from the contract terms. A party is generally not going to be held to this standard unless the contract expressly demands it and such demand is reasonable. Again, this is not going to be enforced very frequently where strict performance is allowed. What we see much more frequently is what we call substantial performance. It occurs when one party fulfills enough of its contract obligations to warrant payment. In a contract for services, a party that substantially performs its obligations will generally receive the full contract price minus the value of any defects. So if you have somebody build a home for you, and one of the requirements of the home building was that there was going to be an entertainment center that was built on the second floor. And they didn't build it. They substantially performed. They got everything else right. They just didn't put in the entertainment center. It's going to cost you $2,500 to have the entertainment center put in. You owe the home builder the full contract price, the $1 million that you paid for your home. You have to pay the full $1 million minus the $2,500 that it will cost for somebody to come in and put in the entertainment center. A party that fails to perform substantially, so you didn't even get close, receives nothing on the contract itself and will only recover the value of the work if there is any at all. Courts consider the following issues in determining if there was substantial performance. How much benefit did the promisee receive? If it's a construction contract, can the owner use the thing for its intended purpose? Can the promisee be compensated with money damages for any defects? And did the promisor act in good faith? So the courts will balance all of those things in their analysis. Personal satisfaction contracts permit the promisee to make subjective evaluations of the promisor's performance. A court will apply a subjective standard only if assessing the work involves personal feelings, taste, or judgment, and the contract expressly demanded personal satisfaction. So artwork. If you commission an artist to make a painting for you and you tell them that this is a personal satisfaction contract, a court would likely apply a subjective standard because it's something that involves personal feelings, taste, judgment. If you go to get an oil change and you tell them that it's a personal satisfaction contract, a court's still probably going to apply an objective standard. An oil change is generally not going to be perceived as something that involves personal feelings, taste, or judgment. The law strongly favors the objective standard because the subjective standard gives unlimited power to the promisee. So the default is going to be objective standard. Parties to a contract have to carry out their obligations in good faith. This is a safety net or sort of a catch-all for the courts. They don't like to use this very often, but they can. Time of the essence. So this is something that tricks students up a little bit on the exam, so it's good to make sure you understand this. A time of the essence clause generally makes contract deadlines strictly enforceable. So merely including a date for performance, this must be done by July 1st, does not make time of the essence. You actually have to use that phrase. You have to say time is of the essence. Courts dislike time of the essence arguments because even a short delay can mean that one party forfeits everything expected to gain from the bargain. If the parties do not clearly state that prompt performance is essential by saying time is of the essence, they're both entitled to damages based on the delays, and they're allowed reasonable delays. If you don't say time is of the essence and somebody shows up a day late or an hour late, a court's going to say, okay, they're entitled to this reasonable delay. They can compensate you for the damage that might have caused, but it doesn't allow you to walk away from the contract as it would if you had said time is of the essence. If a party breaches a contract, the other party generally is going to be discharged, and what courts are looking for is a material breach. And a material breach is one that substantially harms the innocent party and for which it would really be difficult to compensate without discharging the contract. There's a cool concept in the law, I think it's cool, called anticipatory breach. One party makes it unmistakably clear that it will not honor the contract, even if performance for the contract is 6 months or 6 years in the future. When a party makes it unmistakably clear that it's not going to honor the contract, the non-breaching party is immediately discharged from the contract, and they're entitled to file suit for breach of contract right then and there. Contracts often have statute of limitations if you're going to make a breach of contract claim. A statute of limitations is a statutory time limit within which the injured party has to file a lawsuit, and it begins to run, that time limit begins to run at the time of the injury. When we talk about impossibility, what we're talking about is that performing the contract is truly impossible. Nobody can do it. Can't be done legally. A court discharges the agreement. If you have a contract to do repair work, to put a new roof on somebody's house, and the house is destroyed, it burns to the ground. Well, that contract is now impossible. There's no house for you to put a roof on. It's impossible for you to perform. Both parties, the homeowner and the roofer, are going to be discharged from the contract. If honoring the deal merely imposes a financial burden, the law is going to go ahead and enforce that contract. It has to be something that's truly impossible. Courts generally say the following things create true impossibility: if the subject matter of the contract is destroyed, if the promisor in a personal service contract dies, that would create true impossibility, and if whatever was contracted for becomes illegal, a court would say it's now impossible for anybody to do that legally. Commercial practicability and frustration of purpose also sometimes come into play. It might be so dangerous, costly, or in some situations pointless to enforce a bargain that a court will go ahead and discharge it. Commercial impracticability is a situation where some event has occurred that neither party anticipated, and that's important. Neither party anticipated this at the time they entered into the contract, and that unanticipated event makes fulfillment of the contract now extraordinarily difficult and unfair to one party. A court might discharge the contract if there's commercial impracticability. Frustration of purpose involves a situation where an event has occurred that neither party anticipated at the time they entered into the contract, and now the contract now has no value for one party. So something happened, unexpected, didn't anticipate it at the time they entered into the contract, but now it makes the contract meaningless or worthless for one party. Courts consider the following factors in deciding commercial impracticability and frustration of purpose claims. Mere financial difficulties, not enough. Event has to have been truly unexpected. If the promisor has to use some different means to accomplish her task at a greatly increased cost, that's probably a pretty good claim of impracticability. A force majeure clause, which is just a clause that allows for cancellation of the agreement in extraordinary and unexpected events, is significant. The courts will look at that and they'll take that into consideration, but it doesn't necessarily close the case. And now we come to Chapter 19, our final chapter in the contracts unit, where we talk about remedies. What are the remedies that a party is entitled to when there has been a breach of contract? So the first thing that a court does when they're trying to determine a remedy is they look at the interest to be protected. So if there's a breach of contract, which is a failure to perform a duty without a valid excuse, the method a court uses to compensate an injured party is what we call a remedy. And the first step they take is they make a determination as to what interest they're trying to protect. And an interest is just a legal right in something. 4 principal contract interests that a court might seek to protect are expectation, reliance, restitution, and the equitable interest. So let's start with the expectation interest. Expectation damages are future or forward-looking. It's the money required to put one party in the position she would have been in had the other side performed the contract. So if we could fast forward and get to the point where you performed and I performed the contract, what position would we both be in? That's how we come up with the expectation damages. This is the most common remedy that the law provides for a party injured by a breach of contract, and it has a couple of elements to it. It has what we call direct, consequential, and incidental damages. So we're going to talk about each of those in detail on the next slide. But one thing you want to keep in mind is that in contract cases, punitive damages are very rarely awarded. It's not very often you're going to get punitive damages. We're going to look to the terms of the contract to make a decision about what the appropriate damages are. Direct damages, these are damages that flow directly from the contract. These are the most common monetary awards for the expectation interest. A simple example. You and I have a contract. You agree that you're going to buy my car for $10,000. You breach the contract. You don't buy my car. The price of my car, the value of my car has decreased. I turn around and sell it to somebody else for $8,000. I expected to have $10,000 in my pocket. I only have $8,000. The direct damages, they come directly out of the contract. The contract said 10, I've only got 8, you owe me $2,000. Those are the direct damages. Consequential damages are the ones that throw students off. Consequential damages result from the unique circumstances of the injured party. If I was selling you my car for $10,000, so I could take the $10,000, let's say I'm an Uber driver. I could take the $10,000 and I was going to buy a bigger car with that $10,000, and I was going to use that $10,000 to get the bigger car so I could charge higher rates on Uber or through Uber. When you breach the contract, you now have caused me to lose profits because it took me longer to sell my car, took me longer to be able to get the bigger car and be able to charge more. Those would be consequential damages. They result from my unique circumstances of taking that money you were going to pay me to buy a bigger car so I could make more money through Uber. I can only get consequential damages if they are a foreseeable consequence of the breach. Well, the easiest way for me to make it a foreseeable consequence is to tell you, look, I am going to take this money, buy a bigger car so I can make more money through Uber. Now it's foreseeable to you because you know. The Hadley v. Baxendale case tells us that the injured party can recover consequential damages only if the breaching party should have foreseen them. when the two sides form the contract. When a party seeks lost profits as consequential damages, courts will generally award them if the lost profits were foreseeable to the defendant and the plaintiff provides enough information so that the fact finder can reasonably estimate a fair amount. Incidental damages trip students up a little bit on exams as well. These are relatively minor costs that the injured party suffers when responding to the breach. You breach the contract, you refuse to buy my car for $10,000. I had to take out an ad in the newspaper. That cost me $50. That's incidental damage. I had to pay an extra month of insurance, $200. That's incidental damage. I had to store the vehicle somewhere, and that cost me $50. That's another incidental damage. These are relatively minor costs arising out of the breach of contract. They're different than consequential damages. Consequential damages are more substantial, and they result from someone's unique circumstances. The incidental damage that I was just talking about really aren't that unique. You breached the contract, I had to take out an ad in the newspaper. Almost anybody would have to do that. Have to continue paying insurance. Almost anybody would have to do that. Might have to store the car somewhere, depending on where we live. Like, oh yeah, you park it in the garage, and yeah, everybody knows you park a car in the garage and you have to pay. Like, those types of situations are incidental damages, not consequential damages. The Uniform Commercial Code essentially creates the same rules. They just put it in different terms for sellers and buyers. If the seller sells goods elsewhere in good faith, they are awarded the difference between the original contract price and the price that they were able to attain in the open market. Seller also can retain the goods and receive the difference between the original contract price and current market price. And the seller might get incidental damages. And under the UCC, most courts hold that the seller of goods is not entitled to consequential damages. The buyer can cover, and that just means they go out and purchase substitute goods. Has to be a good faith purchase of goods similar to those in the contract. The buyer can then obtain the difference between the original contract price and the cover price. The buyer could choose not to cover, and then they're entitled to the difference between the original contract price and the market value of the goods. Under the Uniform Commercial Code, buyers entitled to consequential damages as long as they made it reasonably foreseeable to the seller. And then the buyer is also entitled to whatever incidental damages may have occurred. So that's the expectation interest. Now we get to the reliance interest. Reliance interest, in the way I like to think about it, is backward looking. It puts the injured party in the position he or she would have been in had the parties never entered into a contract. This remedy focuses on the time and money that the injured party spent performing his part of the agreement. So we see this most frequently with promissory estoppel. There's no contract in place. We've seen the elements of promissory estoppel. Courts generally award reliance damages. In reliance on that promise, which turned out not to be contractual, what money, time, energy, and effort did you expend? Let's compensate you for that. The restitution interest is designed to return to the injured party a benefit that he has conferred on the other party, which it would be unjust to leave with that person. Restitution is awarded generally in three types of cases. If we have breach or discharge of a contract, injured party to avoidable contract rescinds the agreement, and in quasi-contract cases. So we're dealing with cases of a contract breach or discharge. A party breaches a contract, the other party might want to get back whatever it put in. We opened up an art museum together, and what I put into the museum were some classic paintings that I own. I want the paintings back. I don't necessarily just want compensation for the damage that's occurred when you breach the contract. I want restitution. I want the paintings back. We could have avoidable contract. So restitution is a common remedy in contracts involving fraud, misrepresentation, mistake, and duress. Restitution often goes hand in hand with rescission. So you undo the contract, both parties give back whatever it was that they got. And then you can have restitution in cases of quasi-contract, and this may not necessarily be getting back exactly what you put in, but it's being compensated for what you put in. A court may award restitution even in the absence of a contract when one party has conferred a benefit on another, and it would be unjust for the other party to retain that benefit without paying compensation. The idea of specific performance is an equitable interest, and it's one that I find really interesting. It forces both parties to complete the deal. So there's no monetary compensation, there's not restitution. Both parties are actually going to be forced to go through with whatever they agree to. A court will award specific performance, which is ordering the parties to perform the contract, only in cases involving the sale of land or some other asset that is considered unique. So first of all, land is always considered unique. Other things like family heirlooms, art, rare sports memorabilia, secret formulas, patents, shares in closely held corporations, all of those things are considered to be unique and therefore eligible for the remedy of specific performance. Courts can also award injunctions or issue injunctions. A preliminary injunction is before the trial occurs. It tells a party to do something or stop doing something. A permanent injunction happens at the conclusion of the trial and either prohibits a party from doing something or forces them to do something. A court will reform a contract. Courts do not like to do this. They use reformation to save a contract. The most common situation where we see this, out of the things that we've talked about, are the covenants not to compete or the agreements not to compete. If they are overly broad, a court might rewrite that covenant not to compete in order to save the entirety of the contract. This is a concept that students miss on the exam. It's really pretty easy, but there's one particular part of it that students miss when we talk about mitigation of damages. A party that's injured by a breach of contract cannot recover damages that he could have avoided with reasonable efforts. One party perceives that the other has breached or will breach the contract. The injured party has to try to prevent unnecessary losses. Here's the thing that students get confused about. It's the non-breaching party that's expected to mitigate damages. And mitigate just means to keep damages as low as reasonable. Simple example. Go back to the car example. You and I have a contract. You're buying my car for $10,000. You breach the contract. I'm angry that you breached the contract, so I turn around and sell the car to somebody else for $1, even though there was somebody that was willing to buy it for $8,000. A court would look at that and say, I, the non-breaching party, failed to mitigate damages. There was a ready, willing, and able buyer at $8,000. I should have sold it to them. And then I could have recovered $2,000 in damages from you. But because I was angry, I sold it to somebody else for $1 just so I could try and rack up the damages against you. A court is not going to award me that entire amount of damage. They're going to look at, with reasonable efforts, how much could I have mitigated. And then to wrap up Chapter 19, we talk about nominal damages and liquidated damages. These are both concepts that frequently show up on the exam. Nominal damages are a token sum, such as $1 that's given to a plaintiff to demonstrate a breach, but where you cannot prove injury. It's a moral victory. So, again, hitting on the example of the car. You're going to buy my car for $10,000. You breach the contract. I turn around and sell the car to somebody else for $12,000. You were going to buy it for $10,000. I sold it for $12,000. I'm actually $2,000 better off now. Did you breach the contract? Yeah, you breached the contract. If I sue you for breach of contract, the best I could hope for is that I'm going to get nominal damages. The court's going to, require that you pay me $1 just in recognition of the fact that you breached the contract. People don't go to court seeking nominal damages. They go to court thinking they have a better damage claim, and it ends up that a court disagrees and finds that all they're entitled to are nominal damages. And last but not least are liquidated damages. A liquidated damages clause in a contract is a clause stating in advance how much a party must pay if it breaches. An example of this is the early termination clause in your cell phone contract. The court generally will enforce a liquidated damages clause if the following is true. At the time of creating the contract, it was difficult to estimate the actual damages, and the liquidated amount is reasonable. So if on a major highway there's a construction project, it's supposed to take 6 months. At the time they enter into the contract, the city that the highway is in might say to the construction company, for every day past the 6-month deadline that you don't have the highway open, it reduces the amount we owe you by $10,000. It's difficult to estimate the actual damages of a highway being closed for an extra day, an extra hour, an extra 6 months. Who knows? Who knows what that monetary damage is? So as long as the liquidated amount is reasonable, that liquidated damages clause would be enforceable. If it's a $10 million contract and they say $10,000 a day, that might be reasonable. If it's a $15,000 contract and they say $10,000 a day, that might not be reasonable. So you're looking at those two things. Was the amount of damage, potential damage, difficult to estimate, and is the liquidated amount reasonable? So that wraps up Unit 2 review. I wish you all the best on Exam 2. Study hard. Let me know if you have any questions. Make sure you're well prepared and well rested to knock this exam out of the park. Please let me know if I can do anything to help. I'll see you all in class, and I wish you the best of luck.